Mr. Fitzgerald.
Yes, well, my Lord, I hesitate to return to the dreaded section 6.2, but since it clearly has troubled at least two of your lordships, can I try to explain what our respectful submission is? What we submit is that if one looks at the background to the 1976 Act and the change of language there, the first point we make is that in Beccles and Delamore, it's at EB 1223, the key passage, Justice of Appeal Phillips said, and we've cited this in the case, that the manifest intention of these provisions is, in my judgment, to make every effort to prevent the implied repeal of existing laws and to secure the continuance of their validity insofar as is possible to make them conform with the provisions of the Constitution. But all those cases recognise that sometimes you simply can't do that, that even with the extensive powers of modification, the law remains, as it were, unmodifiable, and or some aspect of it remains unmodifiable. And we've submitted that if one looks at the statutory provision, everyone convicted of murder shall suffer death. The board has repeatedly said that the substitution of the word may for the word shall is a legitimate exercise of the modification power. That can't be open to re-scrutiny, as it were. But the words suffer death could not be removed, i.e. you couldn't say from now on no one convicted of murder will ever suffer death, because that would undermine the whole, it would make a nonsense of the legislative provision. Now, therefore, we accept that there are laws, and it may well be that the provision for flogging is another one. You couldn't invalidate the provision that allows for flogging, although we know that that's totally inconsistent with modern human rights law. But you can modify it. Now, therefore, if one looks at 6.2, where an enactment repeals and reenacts with modifications an existing law, so a new law is brought in, particular classes of murderer will not just be executed or be eligible for execution, but they will also suffer solitary confinement until the time of their execution. So it has modifications, and it's held to derogate from a fundamental right guaranteed by this chapter, yes, because it's solitary confinement, in a manner in which, or to an extent to which, the existing law did not previously derogate from that right, because the previous law did not provide for the additional suffering of solitary confinement. Then, subjects to section 13 and 54, that's where you can by a special majority derogate anyway. The provisions of the existing law, that's to say the mandatory or discretionary death penalty, shall be substituted for such of the provisions of the enactment as are held to derogate from the fundamental right in a manner in which, or to an extent to which, the existing law did not previously derogate. Well, the previous law, because it didn't have solitary confinement in addition, didn't previously derogate in that manner. And we say that one can make a sense of that. So if a new law goes further and the additional element involves a further and unacceptable derogation and is not covered as an existing law, you simply revert to the old law to the extent that it was saved. And so we do respectfully, and that again, there's a long constitutional background to that kind of provision where you revert to the old law. So we respectfully submit that that does make sense of it. It has never been the submission of the appellants, nor was it the reasoning of Lord Bingham and the minority, that nothing can derogate from human rights provisions. It was accepted that there might come a point where the only thing you could do would be to invalidate the whole law, and that's not acceptable. And if I can just give the board the analysis, in Lord Bingham's judgment.
I'm so sorry, Mr. Fitzgerald. I've noticed that we don't have a picture of Mr. Mendez.
I think that was from choice, my lord. I think
okay. I just wanted to check he's still with us.
Yeah, no, he is with us, my lord. But I think, as I understand it, he preferred not to be.
Right.
Yes, but I'm.
That's fine.
He didn't want us to see him looking distressed or whatever.
No, quite. Well, I can understand that.
I was making a hash of things. But my lord, that's. My lord, that's our respectful submission. But if one goes to Lord Bingham's judgment in Matthew, he does go through. So this is in the part where he deals with the modification power. He goes through in some detail the way in which modifications take place, and explains. Yes, it's the passages from paragraph 50 at page EB 561. He goes through Candour. He goes through Charles and Phillips. He goes through the Beccles and Delamore, and then very importantly the San Jose Farmers Cooperative Society, all of which were that case. And really what those cases say is there comes a point where it would be judicial legislation rather than modification. There comes a point where you can, like the language that's used, I think, by Lord Diplock in Hines, where it would be you have deprived it of a sensible legislative meaning. But that boat has sailed. You can't say that the substitution of a discretionary for a mandatory is an unacceptable modification because the board's done it about 10 times. So what we, and you see it in Mollison and Rojas and Balake too over the page 563. And then he looks at the modification that's made in Reyes, Hughes and Fox at paragraph 53, page EB 563. And then you see the very helpful analysis of De la Bastide, the Chief Justice, in the Rudal case in the Court of Appeal, saying you can do almost anything. The function which the court is mandated to carry out in relation to existing laws goes far beyond what is normally meant by construing. It may involve the substantial amendment of laws either by deleting parts or making additions. It may extend to the repeal. But there is a limit. And the limit has been drawn in the cases which my learned friend Mr. Mendez referred to, the Herbert, Charles Phillips and Herbert Phillips, which you have at 562B. And the limit has been recognised in a case like Reynolds. So one asks oneself then, why did they change the words from section 3 to section 6? And against what background of linguistic usage? And you have the answer in the series of cases which say you can modify extensively, but you can't invalidate the whole law. Some of the cases are about how you can't invalidate the whole statutory structure. And there's all sorts of cases, San Jose Farmers, where they conduct a kind of blue pencil exercise. They take out the bits which are inconsistent, and then they ask themselves at the end, have we left enough of the original legislation for us not to be judicially legislating, but just modifying?
So you're construing law as referring to what, an act as a whole?
Well, certainly, my lord, there is my first respectful submission is yes, because that's invalidate the law. You've got to leave the law intact. So you've got to leave section 4 with some sensible legislative. It's got to be recognisable, and may suffer death has been held to be recognisably the same section 4, but it's become discretionary rather than mandatory. But my lord, I do respectfully submit that invalidate the law may have to mean legislative scheme in that sense. But certainly, if you look at a provision like Section 4, you're not invalidating the law as a whole. You're simply finding, as my learned friend Mr. Mendes said, you're finding that part of it contravenes the Constitution. And you're asking yourself, can that part of it, which contravenes the Constitution, be cured? And if it can, then you modify. And that's where the kind of, as it were, almost the temporal test comes in. And really the kind of motto of the minorities: modify first, and only if you can't modify, invalidate, but which is and then that's prohibited. And of course, there's a temptation to draw parallels with the Human Rights Act, and I think but the power of modification is more extensive even than the interpretation and under Section 3. But and I think that those of the court that were there for the case of Day and Bush, where my Lord Sales asked many questions about what are the limits of the power of modification. This is, there comes a point where you can't go further. And so, my Lord, I do respectfully submit that that's the background, and that's what makes sense of shall not invalidate. And as my learned friend Mr. Mendes said, what it's saying is there's something you cannot do, not something that you cannot recognise. You cannot invalidate the law, but you can recognise a contravention. And as I put to the court, if one looks at Matthew at paragraph 12 of Lord Hoffman's judgment, Lord Hoffman very frankly confronts the fact. He says at paragraph 12, their lordships consider that for reasons similar to the page number? Page 555, my lord, EB 550, that for reasons similar to those given in Ray's, the mandatory death penalty is a cruel and unusual punishment, and therefore inconsistent with sections 4A and 5.2. He doesn't say, and therefore would be inconsistent but for. He says it's inconsistent with. Well, if it's inconsistent with, that triggers the jurisdiction to modify, to make it consistent. And only if you can't. So there's nothing to stop the court, and there's nothing that stopped the court in Matthew from saying it is actually inconsistent with 4A and 5.2b. And as my learned friend, now, in this respect, the case for the appellants in Matthew is much, much stronger than it was for those in Barbados, because there it says you can't hold it inconsistent with. But the tragedy was that the cases all got lumped together. But if one looks at the Trinidadian words, it shall not invalidate a law. It's something that you can't do to the law. And as my Lord put to me, it may even be that law means the section as a whole, or even the act as a whole, the legislative provision as a whole, that can't be invalidated. And so the
way it was put in by some of the judges in Rudel, I think, was that it was a legislative proposition.
Yes. Well, my Lord, it's almost a question of at what level do you characterise the unit of law that you're invalidating? Because clearly you are invalidating the word shall. You're saying shall is inconsistent with the Constitution and therefore invalid. And if you look at the case of Green-Brown, which is in the bundle, the case on detention during the Governor-General's pleasure, Lord Hobhouse there says you must identify that in the law which is inconsistent with the Constitution and cure that. And so in that case, it was detention during the Governor-General's pleasure. What was the problem with that? It was that it violated the separation of powers. So you take out the Governor-General's pleasure and you substitute the court's pleasure. And by identifying that aspect of the law which contravenes the Constitution and removing it, you modify in such a manner that brings it in conformity. And so, my lords and my lady, that's basically what we say. And just Lord Bingham's judgment, my learned friend's taken you through the broad and liberal construction of protective provisions, which is at paras 42 to 44, the narrow construction of savings clauses, the recognition that the power of modification is extensive, which is at 561 to 564 of the E-bundle. But the most important bit we respectfully submit, just to underline, is paragraph 54 at EB 564. There is nothing strange in a provision which requires a court to construe an existing law with such modifications, adaptations, as may be necessary to bring it into conformity with human rights, but prohibits it from annulling the law. That's really our case in that paragraph 54. And with great respect to Lord Hoffman, he didn't confront that. And he didn't confront the historical background against which, in 1976, against the background of considerable controversy, the controversy was that Chief Justice Wooding, in his report, had said, let's get rid of existing law savings clauses altogether. Then there was another requirement, well, let's look at, there are a whole host of different propositions being played with. So it's not surprising if what happens is there's a sort of compromise. You can modify, but you can't invalidate. And we respectfully submit that does make sense. And my lords, my lady, just on despite the argument that Matthew should now be reviewed, the respondent says that it would lead to a substantial body of laws being rendered invalid or uncertain. Now, we did seek in the reply to identify some of those laws, and my learned friend, Mr. Mendes, has referred the court to some of those. For example, the immigration requirement that prohibits immigration entry to those who are blind, the immigration requirement that prohibits entry to those who are homosexual, the provision that outlaws sex between adult homosexuals, a number of provisions which are, on the Attorney General's own admission, blatantly sexist or discriminatory. What's the problem about saying that those laws should be scrutinised for compliance with the Constitution, and if they can't be modified, they survive, but if they can be modified, they don't survive? It's the same as happens everywhere else in the Caribbean. I know there are some existing laws, provisions. For example, Jamaica has Section 26, but in other constitutions. But throughout the Eastern Caribbean, as my own friend said, you've only got those what we call partial savings clauses. Nothing which you'll see in Hughes and in the cases of Hughes and Fox. That's to say, immunising certain types of punishment from being challenged, which you've got in Hughes at tab 73, page 2705, paragraph 8, or those kind of provisions which are Hughes and Fox. Guyana and Barbados, the General Savings Clause will now be read subject to the CCJ. Bahamas, the court's aware of in the light of Bow. Jamaica, if it's a new law, as the point was in Jamaica, they introduced a new two-tier system of mandatory punishment for the death, for murder, and because it was a new law, it became susceptible to challenge. Now that's actually a public policy reason why one should strain against the interpretation advanced, because it would otherwise mean every time you try to change the law to restrict the death penalty, you lay yourself open to a challenge which you wouldn't be open to if you didn't attempt the reform, which can hardly be, as it were, an interpretation which one should welcome. My Lords, the judicial modification of the statutory provision, I ran through it this morning. Can I just give you, you'll see Belize, the 5-year thing, you can see that at tab 11 in the Ray's case. Fox is in St Kitts, that's tab 66. Hughes, St Lucia, tab 73.
Giving us tabs will be of limited value. If you've got electronic page numbers, that would be more helpful.
Oh, I'm so sorry. Okay, well, I'm so sorry, my Lord. Okay, Ray's.
Well, if you're not going to refer to them, then if you just give the number, you're not going to take us to them. But if you
Yes, my Lord, I'm so sorry.
to look at something.
Yes, no, I just really wanted it to refer.
Yes.
If you just get the name and the jurisdiction, would that assist, my Lord? So it's Ray's is Belize, and that refers to the sunset clause in Belize. Fox, St Kitts, and I've given you Hughes is St Lucia, and you've got that at page 2705, the savings clause there. Watson for Jamaica, and Bow in respect of Bahamas, which we'll hand up. And then as to there being a sensible new regime of discretionary punishment, can I just give you that reference, the judgment of Lord Carswell in Trimmingham, volume 13, tab 128. And that's at EB 4173, paragraph 21. Where he explains that the new restrictive approach to the discretionary death penalty is governed by certain criteria that have been developed by the courts. So
4173 of what paragraph?
it's paragraph 21, EB 4173, my Lord, where he explains.
There aren't paragraphs on my copy.
No, nor mine.
Oh, well, it's.
This is in Reynolds.
Oh, I'm so sorry. Well, Trimmingham is volume 3, tab 128. Oh, sorry, volume 3. I'll give it to you, my Lords. Yes. Trimmingham is 128, and it's the relevant passages at 4713. I'm so sorry, 4713. And he says the two principles that now govern it. There's a paragraph. It is paragraph 21. It's 4713. Does my Lord have that? Yeah. Then, so I think the court has the submissions we make about the power to modify, and that you must read 6.1 and of the Constitution, 5.1 of the Constitution Act together. My Lord, it goes even further than that, because Section 14 of the Constitution, the remedy provision, effectively incorporates the power to modify. Because so you have Section 14 of the Constitution, which is set out in tab 3. Yes, at page 433 of the electronic bundle, anyone who alleges that their rights have been contravened can go to the High Court. Now, one of the, as it were, one of the powers that was already recognised that the High Court had was the power to modify, which is referred to in the Section 5.1 of the Constitution Act. And that power to modify, it was well recognised by then, was one of the powers of remedy, perhaps one of the key powers of remedy, exercisable under Section 14.1. So if you look at the act that gives birth to this Constitution as a whole, it contains the power to modify, and then the schedule with this. If you look at the Constitution itself, you have to balance 6.1 against the power of remedy in 14, which has, from time immemorial, and certainly from the 62 Constitution, carried with it the power to modify. So if you look at it holistically, as the CCJ said one should do in Nervais and in McEwen, then you look at the two together, the principle modify first, and only if you can't modify, run into the brick wall of you can't invalidate,
Has yet had an opportunity to look at the cases to which Lord Bingham refers in his dissenting judgment in Matthew, where the power of modification was used. Were any of them relating to provisions which were otherwise breaches of Section 4 or Section 5 of the 76 Constitution?
Yeah, yes, my lord. Yes,
They were.
Yes, well, I mean, some of them are violations of other human rights provisions, but yes, I mean, the ones he looks at include the Rays, Hughes and Fox. He looks at those.
Yes. So, while Section 5 of the Act itself presumably has a power to modify which can apply to other provisions of the Constitution, other than Section 4 and 5.
Oh, absolutely, my lord.
But you're saying that the jurisprudence to which Lord Bingham refers included modifications,
yes,
in order to render a provision compatible with sections 4 and 5 of the Constitution.
Yes, my lord. I think yes, my lord. That is right. I mean, that, or the equivalents thereof in other constitutions, because he's looking. I mean, San Jose's Belize, Beccles and the whole
shorthand.
But yeah, absolutely, my lord. Yes, but both. But of course, some of them are about separation of powers, which is not located in Section 4 and 5 or the equivalents thereof, but pervades the Constitution. And so, well, the court has the point about Beccles and Delamore and Charles and Phillips. Herbert and Phillips and Reynolds, and we say that it's significant that it was against the background of that the terms of Section 6(1) of the Constitution were formulated. My lords, I think I should move on.
Mr. Fitzgerald, the present scheme is that the advisory committee advises the minister, who then advises the president in relation to a death penalty.
Yes.
What are the constitutional obligations on the advisory committee and on the minister and on the president?
Well, my lord, that's dealt with in the case of Lendor, where my Lord Hughes gave the judgment. But basically, it has now been established that they have a duty to give natural justice. Although subsequent to the Lendor case, none of them have had natural justice. There's been 4 years, I think, with absolutely nothing happening, although they've written time and time again saying, what are the new procedures? So with great regret, one has to say that it doesn't work. And moreover, Lord Bingham recognised in Rays, I think it's paragraph 47, that it was no substitute for a judicial sentencing to say, oh, well, the executive will do something. In other words, the provision for a prerogative of mercy can never be a substitute for judicial sentencing. That's in paragraph 47 of Reyes.
So what's the page number?
My Lord, I'm just going to locate it in 1 sec, if your Lordship will forgive me. It's tab 11. It's tab 11, but I know your Lordships don't have tabs. It's paragraph 47. So I think it's paragraph 47 is at page EB 708. The board cannot accept that it's a substitute, that you've got the prerogative of mercy, as the Attorney General has accepted the decision in Laureanas was based on a far more limited material. It is clear that such a non-judicial body cannot decide what is the appropriate measure of punishment to be visited on a defendant for the crime he has committed. And what Lord Bingham says in Matthew is, of course, you still need the safety net of the prerogative of mercy, even when you've got judicial sentencing. But it is a safety net of executive mercy. It is not a substitute for a judicial determination. And my Lord, so that's the position. So if I can turn then to the separation of powers, can I just give 4 propositions and then, to the extent I can, develop them? Firstly, we submit a law that is inconsistent with the separation of powers can be modified or invalidated because the basis of the inconsistency is not by reference to Section 3 or 4 of the Constitution, but by reference to a wider principle that underlies and pervades the whole Constitution. That's the separation of powers. I can just give you that's in Mollison, which is from EB 619 onwards, CPSAD at EB 4320, and in Johnson, Lord Roger recognised that an inconsistency founded on, quote, some other provision of the Constitution than sections 4 and 5 could be the basis of intervention. That's at EB 2875 to 2876. That's a snapshot of our point. So it's all, the classic case of that is Hines, the judgment of Lord Diplock, and then the case of Mollison, which is at EB 619 onwards, where Lord Bingham finds at EB 630 to 632 that you can, as it were, bypass the existing law's protection altogether, where you're relying on the separation of powers. And that's because the separation of powers pervades the Constitution. It's not located in section 4 and 5. And CPSAD recognises that in the Trinidadian context. So that's the first proposition. So
have I understood you're not pointing to any particular provisions in the Constitution, you're just saying that there's some wider principle?
Exactly, and that's what Lord Diplock said in Hines. It's the principle of the separation of powers pervades the Constitution. It's what Lord Bingham said in Mollison, and he said that. And would it assist if I just showed you that? It's at page EB 630 to 632. So volume 1, tab 9. Or volume 1, tab 9. I think Mollison is in the bundle. And one sees that in Mollison, Lord Bingham at paras 12 to 13, which are at page 630 to 631, you can see at page 630, para 12, no doubt mindful of the obstacle presented by section 26.8, Mr. Fitzgerald, with the support of Dr. Barnett, based his primary attack on section 29, that's the detention during the Governor-General's pleasure, not on its incompatibility with specific rights, but on its incompatibility with the separation of judicial from executive power. And he cites Hines then, and you can see, my Lord, there, the citation at the bottom of page 630. What, however, is implicit in the very structure of the Constitution on the West is that judicial power is to continue to be vested in persons appointed to hold judicial office. And then there's what cannot be done is set out in the Hines. And that's quite helpful because that sets out the fact that at that time it was thought perfectly permissible for Parliament to fix a penalty, which you can see at 631 at D. It is permissible for the Parliament to confer the discretion to determine the length of custody for criminal offence upon a body. It would be equally permissible to a less well-intentioned to confer the same discretion upon any person. And then you can see...
But what it said in Hines at the start of the quotation is it's impermissible to determine the severity of the punishment to be inflicted on an individual member of the class.
No. Oh, no, I accept that, my Lord. I'm relying on this, but I'm just showing it. I'm relying on this as authority for the proposition that the separation of powers does not derive its force as a principle from sections 4 and 5 of the Constitution. And you can see that at paragraph. I just wanted to show you that you do have there, and it's fair that I should point it out, that it says there at 631E that you can have a fixed penalty. describe, the legislature can prescribe a penalty. One sees the prescription of fixed penalties statement of a general rule, which is one of the characteristics of legislation. So at that stage of, as it were, constitutional development, it was not considered inconsistent with the separation of powers for Parliament to fix a penalty such as the mandatory death penalty for murder.
Can I just be sure I understand, Mr. Fitzgerald, where this strand of your argument fits into the structure? You've been advancing an argument that the mandatory death penalty is unconstitutional because it's cruel and unusual punishment. And the issue then is whether it is saved by the savings clause in Section 6 of the Constitution, and you argue that the relationship between that provision and Section 5 of the Act is such that the savings clause should not be construed as saving an unmodified mandatory death penalty.
My Lord, yes.
Right. Now, this is an additional argument.
Yes, this is an alternative argument.
An alternative. So,
additional.
So,
my Lord,
does this argument? I'm wondering. I mean, this argument to be useful has to be one that applies if you're wrong on the first argument.
Yes, that's it, my Lord.
Yeah.
So my Lord, can I just summarise the position? I probably better.
Well, I'm just wondering if you're wrong on the first argument.
Yes.
And the unconstitutionality, leaving Section 6 to one side,
yes,
the unconstitutionality of a mandatory death penalty doesn't get you home because of Section 6.
Yes.
Establishing that the mandatory death penalty is unconstitutional for another reason,
yes,
each of a separation of powers, wouldn't get you home either if Section 6 is construed as it was in Matthew.
Well, my Lord, it would, because what Section 6 says is, Section 6 is simply disables an attack based. So nothing in Sections 4 and 5 shall invalidate. Well, we're not relying on Section 4 and 5 in our alternative argument.
Yes, I'm with you now.
And
thank you.
so, my Lord, and that's actually the structure of the separation of powers argument in all the cases where it's been relied on. And what Lord Bingham was saying, because there were, for example, in Mollison, it was detention during the Governor-General's pleasure. There were arguments that it denied them the protection of the law under the, if I can call them the human rights provisions, the equivalent of Chapter 3. You couldn't win on that because of the existing law's protection provision.
Yes, so if you locate the unconstitutionality somewhere other than Sections 4 and 5, you're home and dry.
Yes. So if the separation of powers principle is violated, and we can rely on that, or if the rule of law provision is violated, then we're not relying. It's nothing in Section 4 or 5. We're not relying. Well,
neither is the provision, but you would say that there are principles that are immanent in the Constitution.
Yes, I think pervasive is sometimes used, but yes, inherent in the. So, and that's the whole reasoning in Mollison, where Lord Bingham says, well, you know, they recognised they couldn't take it under 26(8), but they relied on the wider principle, and they succeeded, and that's been the basis of a whole series of decisions since, striking down detention during the Governor-General's pleasure in numerous jurisdictions.
Now, Mr. Fitzgerald, Mollison was a case where the offending, or the provision under scrutiny, was a provision which gave a sentencing function to the executive, wasn't it?
I accept that.
You are saying, are you, that we should treat a provision for a mandatory death penalty in the same way?
No, I'm not, my Lord. Oh. No, the point that we lost on, if I can put it, expressly lost on in Matthew, was saying that the wrong was effectively to give to the executive the power to decide who should live and who should die, and that was rejected by the majority. Yeah. And although the minority said they saw the force of it, they said it doesn't give an independent ground of challenge.
Yeah.
The thing they didn't deal with, although it was argued, was that it's the legislature dictating in the area of capital sentencing that you must impose this penalty even though it's cruel and unusual.
Right.
And there are quite so this is.
I don't think you're saying it's because it's cruel and unusual, are you? You're saying it's because it's taking away from the normal sentencing organ, in other words, the judiciary,
Yes.
the power of discriminating as between individuals.
My Lord, that's the. Can I absolutely? There are various dicta in various cases, including, of course, Nervais, where they say the determination of the appropriate punishment, particularly when it's a massive punishment, is a quintessentially judicial function, and that the legislature can't tell you how to perform that. Now, when it comes to the death penalty itself, there are very specific dicta which run through all the cases from the American cases of Woodson and Carolina, the Indian cases of Me Too, all the decisions of the Inter-American Commission and Court, which say death is special. The penalty of death is unique. It differs more from a sentence of imprisonment than a term of 1 day does from 100 years. That's what they say in Woodson and North Carolina. It's a massively different thing. And that there it is essential that this should be a judicial function, the determination of who should live and who should die. And that's that. And one of the reasons.
So it's peculiar to death.
Well,
because the question that I was going to come to, which I'm sure you'll deal with eventually, is if you're right about this,
yes.
Why aren't all mandatory sentences contrary to the inherent concept of the separation of powers?
Yes. Well, the answer to that, my Lord, is
the one you've just given.
Yes, is that that there are dicta again that if you're dishing out life sentences, but certainly in relation to the death penalty, and so my Lord,
anyway. You would take your
but my Lord, I'm very grateful for the intervention. It actually helps to focus the point. But as my Lord Reed has put to me, it's the words where you're relying on 4 and 5. So we're not relying on 4 and 5. We're relying, as Mollison makes clear. Can I just? I mean, there is the paragraph 13 at page 632. He says there appears to be no reason why the reasoning in Hines does not apply to the present case. And then it says the separation between the exercise of executive and legislative powers. Such separation based on the rule of law was recently described by Lord Steyn as a characteristic feature of democracies. In the opinion of the board, Mr. Fitzgerald has made good his challenge to Section 29 based on its incompatibility with the constitutional principle that judicial functions must be exercised by the judiciary and not by the executive. Now, if you substitute, but not by the legislature, we're in our territory. Now, what the second...
I just don't understand that, because the judicial function is being exercised by the minister on the advice of the advisory committee. And to the president, who's a branch of the executive.
No, my lord, that's not the judicial function, that's the mercy function.
Well, but the two may be conflated, because in order to decide what you should do by virtue of mercy, you've got to first of all decide what's the appropriate sentence.
Well, my lord, there is the Lord Bingham in Rays says that is not a substitute. I mean, at paragraph 47, but there is, and so too does the Inter-American Court and Commission repeatedly say it's very good to have a prerogative of mercy, but that is a long stop, not a substitute for judicial sentencing. And Woodson and North Carolina.
I don't understand what the advisory committee is actually doing.
Well, I think we share your doubts, because they never seem to function. But I mean, but quite apart from that, my lord, what they're doing, and Lord Bingham makes that clear, is exercising a power of mercy. They start from the presumption that the death penalty is justified, and they decide whether they're going to.
Well, they don't, because the respondents say that they will be taking into account. One of the factors that they'll be taking into account is that the mandatory death penalty is a cruel and inhumane punishment.
Oh.
And so I don't understand how they can take that into account and yet start from the proposition that it's the appropriate sentence.
My lord, at the moment they don't hold hearings. They don't. They don't. I mean,
the public don't have access.
No, they don't have. They don't. But they don't hold. They don't have to give you an oral hearing. And
they don't give reasons.
Well, There is a decision which my Lord Hughes refers to in the Lendor case, which said they ought to obey the principles of natural justice. All I can say is they haven't yet done so, and my Lord Hughes said in Lendor, if it turns out that they don't function, we may have to look at this again. And the answer is they don't function. But my Lord, it can never be. This is just simply a matter of principle. A body dispensing mercy, however they perform that exercise, cannot be a substitute for a judicial determination of the appropriate penalty, certainly when it comes to the death penalty. And that is because in Woodson and North Carolina, which is summarised in Ray's, they make it clear that there has to be a judicial determination. That was the whole ratio of the Reyes case, that there has to be a judicial determination that it's not good enough to say, well, the prerogative of mercy. The prerogative of mercy was exactly the same structure in Belize, in Reyes, as it is in Trinidad. It's a long stop. It's not a substitute.
Would it be fair to draw an analogy with the principle of US law that the federal authorities cannot, or the legislature cannot lay down sentencing guidelines, but must involve the judiciary? That's been established by the Supreme Court on more than one occasion.
My lady, absolutely. That's why, yes, absolutely, my lady. I mean, we obviously have to do. By the time that Reyes was decided, Neville Lewis had already decided that the prerogative of mercy was judicially reviewable. The argument was put in Fox in respect of St Kitts and in Belize in respect of Reyes that the real sentencing function is done adequately by the executive, and it was roundly rejected in both cases, and I've shown you the reference to paragraph 47 of Reyes. It cannot be a substitute that a body which has often executive members in it, I think the Attorney General's a de facto member of it, can decide appropriately who should live and who should die. That has to be done in our respectful submission by the judiciary. And my Lords...
But correct me if I'm wrong, but my understanding of the Constitution is that the Minister needn't accept the advice of the Advisory Committee and the President needn't accept the advice of the Minister.
Certainly the Minister needn't accept the advice of the I think the President has to do what the Minister tells him to do, but my Lord, that's right, my Lord. It's an executive function, my Lord.
Forgive me, Mr. Fitzgerald, there are two quite separate points here. The one that you've moved on to is at invitation, is the role of the prerogative of mercy.
Yes.
Just before we leave that, am I right in understanding that that is provided in Trinidad by Section 87 of the Constitution?
Yes.
So it is itself an entrenched provision.
Yes, I accept that, my Lord. In other words, nobody can be executed without the prerogative of mercy being considered.
But the procedure, which may or may not work as well as we would all like, is a procedure which is provided for by the Constitution.
Yes, but all right. Under the heading, prerogative... Sorry, I'm not trying to be... But if one's asking what is the exercise that's being performed, it is an exercise of determining whether the penalty imposed by the state should be mitigated, not what is the appropriate penalty in the first place.
Yes.
And so, my Lord, it will always be second best to the exercise of the judicial function. But, my Lord, what the point I respectfully make is this. In Matthew, the challenge that was confronted under separation of powers was a challenge that the result of having a mandatory sentence is that the effective decision makers are the executive. Yes. And they rejected that. And I can give, it's the majority at paragraphs 27 to 28, EB 553, and the minority at paragraphs 62 EB 569. They rejected that. The thing they didn't deal with, and the argument here, is solely focused on the fact the legislature is taking away what should be an exclusively judicial function from the judiciary, because it is taking away the power to determine an appropriate sentence in an individual case, in circumstances where it's universally agreed that not every person convicted of murder deserves to be punished by execution.
Yes,
That's universally agreed.
That is what prompted the question that I was trying to ask a little while ago, which is, if you're right about that, why are not all mandatory sentences provided for by legislation in accordance with whatever the constitutional arrangements may be? Why is not every mandatory sentence an infringement of the unspoken, pervasive principle of the separation of powers?
And my Lord, my respectful answer is because death is special. And
where do we get that from?
From Woodson and North Carolina, as cited in Ray's. My Lord, can I just show you that?
Thank you.
If we look at Ray's, which is at tab 11, sorry, I know pages are better, but it's at page 685 onwards. But if you go, my Lord, with respect, can I just take you to page EB 701, the citation of Woodson and North Carolina, EB 701. And then it's about what the problem is that this that set out at third constitutional shortcomings, its failure to allow the particularised consideration and record to be considered before the imposition upon him of a sentence of death.
So whereabouts are you reading from, sorry?
So, my Lord, it's the quotation from Justice Stewart's judgment in Woodson, and it's at 701G, my Lord.
Yeah, and the question there was whether a mandatory death penalty in North Carolina conflicted with the Eighth Amendment of the US Constitution.
Yes.
Now, does that give us, do you say, I think you do,
yes,
a universal principle which can be transplanted, in this case to Trinidad, to strike down the mandatory death penalty, which is provided for by legislation?
My Lord, yes.
Okay.
And my Lord, can I just show, because of course there was a statute in the US too, but if I can show you page 702B, while the prevailing practice of individualizing sentencing determinations generally reflects simply enlightened policy rather than a constitutional imperative, and I do ask you to focus on the words individualizing sentencing, we believe that in capital cases, the fundamental respect for humanity underlying the Eighth Amendment requires consideration of the character and record, this, etc., as an indispensable part of the inflicting the death penalty. This conclusion rests squarely on the predicate that the penalty of death is qualitatively different from a sentence of imprisonment, however long.
But this isn't, I think, concerned with the separation of powers. This is concerned with the Eighth Amendment, which is cruel and unusual punishment.
I accept that, my Lord, but if you look at the cases and then they're developed, I mean, that's the starting point. But this is authority for the proposition that death sentencing is wholly unlike the imposition of imprisonment. If one asks oneself, what was it that the US Supreme Court, and indeed we've got the Indian Supreme Court next at EB 703 in the Me Too case, where they say at 703, a standardized mandatory sentence fails to take into account the facts of each particular case. And then they say you've got to have so final, so irrevocable and so irresistible is the sentence of death that no law which provides for it without involvement of the judicial mind.
Again, I'm terribly sorry. What paragraph are you reading?
At 703, EB 703, my Lord. Go to the about C. Does my Lord see it?
Yes.
So final, so irrevocable and so irresistible is the sentence of death that no law which provides for it without involvement of the judicial mind can be said to be fair, just and reasonable.
But this again isn't concerned with the separation of powers. It's a constitutional provision protecting the right to life, we're told, at the foot of the previous page.
My Lord, I accept that, but I'm going to come on that it's part of the rule of law that you're not arbitrarily deprived of life. But what I do submit is that if we look at Nervais, where they are dealing with the death penalty, these cases are, and then you get the Macmillan about the need for sentencing options, and then if you look at Edwards and Bahamas, which is at 704, paragraph 40 of the judgment, the need for consideration of the individuals, Downer and Tracy, which is at page EB 705, paragraph 41B. Commission's view that a common precept is developed whereby the exercise of guided discretion by sentencing authorities to consider the essentially medicating circumstances is considered to be a condition, rational, humane and fair imposition. Now, in all those cases, it's the need for a judicial consideration of the merits of the case as opposed to a legislative predetermination. And if you ask yourself, what's the underlying ratio? It's that judges ought to consider the merits and that the legislature shouldn't predetermine them. So it doesn't actually matter that in those cases, that precept, that the legislature should not dictate to judges what they do, they should be able to consider the individual circumstance of the case. That's the underlying principle. The fact that it's been first enunciated in Eighth Amendment cases or arbitrary deprivation of life cases doesn't matter. What matters is that it has become a principle of human rights law in relation to the death penalty, that unless a judge exercises individual consideration of a case, free from legislative dictation of what he should do, you haven't had a proper deprivation of life. Now, what is that in the end but a determination that there are certain matters which are so important that the legislature should not dictate to the judiciary what they do, and that is the separation of powers. Or it may be the rule of law, but it's both.
Sorry. So I understand this part of your argument, the separation of powers argument. Essentially, it's rooted in the approach to a constitution laid down in Hines, which is a seminal decision, where one interprets the constitution in the light of the Westminster tradition to which it gives effect.
Yes, ma'am.
Might it not be said that the Westminster tradition has always recognised that the legislature can impose mandatory sentences for particular categories of criminal offence? And so the fact that that is what happens in this case does not offend against such separation of powers principle as one might have otherwise located in the Westminster tradition.
Well, my Lord, obviously the question is, can that underlying principle evolve? As in Nervais, they evolved it, as it were. But my Lord, I accept that that's the historical origins of the Hines, if I can call it the Hines doctrine. The trouble in the end is that they're two sides of the same coin. It's because the legislature is telling the judges, whatever the merits of this case, this is what you must do. And in that sense, the legislature is usurping the judicial function. But the only body left to do what the executive shouldn't be doing, which is to determine the punishment, is the executive. But in fact, what the executive should be doing is, as it were, a long stop, well, I'm going to exercise mercy. So they are both, but whereas focusing simply on the executive are in fact performing a judicial function in these cases was the point that was not accepted, if I can put it that way, in Matthew. What we say is that Nervais focuses instead on the fact that certainly in capital cases, it's essential that the legislature shouldn't dictate to the judiciary what to do.
Mr. Fitzgerald, can I just go back to the answer that you gave me in relation to Hines? You said, well, couldn't the tradition develop? So that seemed to me to be some form of living tree.
Yes.
Principle.
Yes, my lord.
But living tree, as I understand it, has been applied to particular provisions in constitutions. I rather understood that the point Lord Diplock was making in Hines was you interpret the Constitution in the light of the established tradition as it existed at the time that the Constitution was adopted. That doesn't suggest that you somehow apply living tree to a tradition which is already fixed at that time.
Well, my lord, if one has, if one has, as it were, a broad principle that it's wrong in certain cases for the legislature or the executive to take away a judicial function.
That's my point. You don't have that principle in relation to the legislature at the time when the Constitution is adopted, because that's not part of the Westminster tradition at that time. However, it may develop in the future.
Yes. Well, my
don't
lord,
know.
well, my lord, I do respectfully submit that when one looks at the particular case of capital sentencing, there has been a development towards the recognition that it's a quintessentially judicial function. So
I appreciate that you're saying that
yes.
there's been this development, but
okay.
with respect, I'm not sure that's quite addressing the point that I'm putting to you, that if you go back to the Hines foundation for this argument,
Yes.
as I understand it, but you tell us if I'm wrong in this, Hines looks at the tradition, the Westminster tradition, as it stood at the time when the Constitution was adopted. I don't think you've shown us anything to suggest that the Westminster tradition at that time meant that the legislature could not lay down mandatory sentences in relation to particular categories of offence.
I can't. What I can show you is the analysis in the case of Bow, that everybody had already, by then, as it were, already recognised that not every case of murder deserved the death penalty. Somebody had to perform the task of the determination.
It may be that this is not that sort of case, in the sense you've got a written constitution which sets out the judiciary's power, not the judiciary's powers, but has a separate set of provisions relating solely to the judiciary, and a separate set of provisions dealing with the executive, and then a set of provisions dealing with Parliament and the election of Parliament and so on. So that you have got three separate entities, and it becomes then a question of interpreting the Constitution as to where a particular power falls.
Yes. Well, my lady, my respectful submission would be that there is, I mean, that Nervais rightly says that the, can I just, would your ladyship just forgive me if I, because I've got precious of time, if I just jump ahead a moment. In Nervais, and this is at paragraph 70, EB 669, the President, Justice Byron, says the mandatory nature of the death penalty is antithetical to the separation of powers doctrine. It reduces the court's sentencing role to rubber stamping the dictates of the legislature. The mandatory element impairs the judicial process and compromises judicial legitimacy. And Justice Anderson says, and this is at EB 112-683, the fact is that the judicial power to impose an appropriate sentence based on considerations of fairness and the cruelty of the punishment cannot be constrained by the legislative direction to oppose an appropriate sentence. So clearly the Caribbean Court of Justice did develop that principle. My Lord, I accept your Lordship's point that...
Well, can I just put to you directly, and so you can answer it? A concern that I have, if we went down the line of submission that you're inviting us to go down, as I understand it, I can see how the living tree doctrine works in relation to express provisions in a constitution. But there's always the discipline in that sort of case of the words themselves, that the judges just can't make up anything at all. They have to identify the living tree where it's taken, that language, and see that it does fit with the language. But if you start off with something as vague and general as a principle, which you do for this part of your argument, rather than a particular provision in the Constitution. And then you build on that already relatively vague principle and say, and moreover, the living tree doctrine applies to that principle. My concern is that you're sort of compounding uncertainty upon uncertainty, and giving, it might be said, judges far too great a role in being able to interpose their values rather than the true values of the Constitution into the Constitution itself.
Well, my only answer to that, my Lord, is that really for decades it's been recognised, it's a simple recognition, that not everybody convicted of murder deserves to die. If the legislature imposes on the judiciary a duty to impose a sentence, which in many cases will be a cruel and unusual punishment, because it's simply inappropriate, then we would say that the legislature is usurping a judicial function. I can see, my Lord, how it's easier, and traditionally it has been done, to analyse this in terms of a breach of the prohibition on cruel and unusual punishment. But in fact, if one looks at the underlying reason why it is castigated as cruel and unusual punishment, it's precisely because the judiciary are deprived of their classic judicial function of determining the appropriateness of the penalty, having heard evidence. And so that would be my answer. My Lords, I think I ought to...
So I think the logic of your argument, I think, is that you've shown us authority, American authority, where the need for individual judicial consideration was read into the prohibition of cruel and unusual punishment, and you've shown us Indian authority where a similar requirement was read into the right to life.
Yes.
But as far as those authorities go, they don't get you home, because those particular guarantees against cruel and unusual punishment and the right to life are in sections 4 and 5 of the Trinidadian Constitution. And so you have to invite us, I think, to infer from those authorities there is a further principle,
yes,
essentially one of separation of powers in the sphere, which is not to be found in sections 4 and 5, and therefore is not caught, if you like, by section 6.
Well, my Lord, that is my respectful.
Yeah.
We also, my Lord.
That has to be the logic of your argument.
Yes. Can I just also, because the rule of law, the case of Koirati, which you have at volume 12, tab 120, can you just give me the page number, Koirati? It's at paragraph 7, it's page 4445. So we have here, Trinidad is a democratic republic. We say that in Koirati, and this is at 4445 and 4447, paragraph 12, they say that the principles implicit in it being a sovereign democratic country includes the separation of powers and the rule of law, because the rule of law is wider, and that it is, this is at paragraph 15 of Koirati, it is an operative and enforceable right. Now, that is this board interpreting very similar language to the language in the Trinidad Constitution of it's a democratic republic, and saying that implicit in that is the doctrine of the separation of powers. So my Lord Sales, I think I'm getting that from something in the Constitution itself, as interpreted by this board in Koirati, that it's Mauritius shall be a sovereign democratic state, carried with it a guarantee that fundamental rights should be protected by an impartial and independent judiciary. And then they say at 4449, that's an operative and binding provision. So that is locating that principle in something specific in the Constitution, which is susceptible to development with the living tree doctrine. But moreover, I would respectfully submit that it goes further. The reason why the separation of powers is said to be implied in the words a sovereign democratic state is because you can't imagine a democratic state of the Westminster model that doesn't subscribe to the rule of law. And the point is that the rule of law requires that no decision, such as the decision to impose the death penalty, should be arbitrarily taken. And we do respectfully submit that, quite apart from the separation of powers, there is powerful authority. The Indian case that my Lord, Indian Supreme Court case, and the Inter-American Commission and Court say it is arbitrary. Arbitrary. And therefore, we would say inconsistent with the rule of law to have a system which involves taking away someone's life without an opportunity for the matter to be considered by an independent judge before the death penalty is imposed.
Doesn't it also, the rule of law also include your argument that you must have a judicial branch with a judicial function which is permitted to carry out the judicial role?
Yes, Melody. I can't take you in this time to all the cases, but the case of Dodo, which I can just give you the reference to, says, and the case of Dodo expressly says that it must be a violation of the separation of powers if the legislature compels a court to pass a sentence which is a cruel or disproportionate sentence. Now, it is an inevitable consequence of Lord Hoffman saying that it's a cruel and unusual punishment, that in many cases the judiciary will be being required to do just that, to impose a cruel and unusual punishment. And that's Dodo at EB 2057, volume 5, tab 56, but it's EB 2057 at paragraph 33, Roman 5. For the purpose of this case, sufficient to hold that the legislature is not empowered to compel any court to pass a sentence which is inconsistent with the Constitution. Now, we know, because Lord Hoffman has told us this, that the mandatory death penalty contravenes the prohibition on cruel and unusual punishment. But somehow one can't rely on section 4 and 5, but one can rely on the rule of law and the separation of powers doctrine and the right not to be treated arbitrarily, quite apart from section 4 and 5, to say it would be arbitrary, it would be contrary to the rule of law for someone to be sentenced to death without the quintessentially judicial function being exercised by the judiciary. And can I just make one more point? And this really is an answer, I hope, to the concerns expressed by my Lord Stevens. If you say, well, it's all okay, because although the judge says you will be hanged by your neck until you are dead, there's a good chance that the executive at a later stage will say, well, actually, we'll let you off. You are, as Lord Bingham said in the case of Rays, grossly underestimating the impact of being told by a judge, you will be hanged by the neck until you are dead. That has some meaning. Why should a judge say that if it's a cruel and unusual punishment? And it's no good to say, oh, well, somewhere along the line, if you're lucky and if your case is considered, or if you have sufficient influence to influence the prerogative of mercy, you won't in fact be executed. It is an arbitrary violation of the rule of law for a judge who knows that it's not merited to say you will be hanged by your neck until you are dead and God have mercy on your soul, or whatever it is. It carries some weight to go that that one's going through something which is a charade or a farce or a perversion of the principles of law on the hope or expectation that somewhere along the line, the executive, in the form of the advisory committee, will put it right. So I respectfully submit that what the Constitution contemplated was a power of mercy, and it's no substitute for an exercise of justice by the judiciary themselves. And so to that extent that Section 1 is capable of dynamic development in its meaning, is capable of being interpreted in line with the living tree doctrine, I do respectfully submit that the board should also determine that it's a violation of the rule of law and of the separation of powers enshrined in Section 1 to maintain the mandatory death sentence. My lords, I think I've probably exceeded my time now. I'm sorry.
Slightly.
My learned friend, Mr. Hussain, I know is due to address you next. So unless I can assist, I'm sorry I've had to rush through them.
I don't feel you've been rushed. We've certainly absorbed what you had to say, Mr. Fitzgerald.
Well, my lord, much of it is in the case under the head. We do deal with the rule of law and with coirati, and I also draw attention to the case of Francis, which is at EB 2367, where and that's quite interesting. In answer to my Lord Hughes, that it was a minimum sentence of 25 years for possession of dangerous drugs for the purposes of trafficking, and it was said that that was indiscriminate and arbitrary and capricious. All the more so to impose indiscriminately the death penalty without consideration of individual merits. And if one's using the language as was used in Francis, of it's arbitrary and capricious, that must be inconsistent with the rule of law. Now, it's quite true that they there relied on Section 4A.
Could you give me the page number?
Oh, I'm so sorry. It's 2367, Francis, my lord. And the relevant finding is at page 2444. It indiscriminately applies the mandatory minimum penalty to all offenders, irrespective of the nature of the offence, the culpability of the offender, and the mitigating circumstances of the offenders. Now, I accept that the finding was it was inconsistent with Section 4A of the Constitution, because it imposes a penalty which is arbitrary, capricious, and oppressive. But it's very difficult to see how the imposition of a penalty that can be castigated as arbitrary and capricious is not also a violation of the principle of the rule of law, which is enshrined in Section 1 of the Constitution in the expression, shall be a democratic republic. So, my lords, I think those yes, and my learned friend gave you the 6 reasons why we say Matthew should be overruled, and they're set out in the case at paragraphs 210 to 216.
Thank you very much, Mr. Fitzgerald. Now, Mr. Stevens.
My lord, it's going to be Mr. Hussain first, if that's agreeable to the board.
Yes, certainly. Thank you very much. Mr. Hussain.
Thank you very much, my lords. My lords, my lady, the state in this case respectfully submits that the court should not accept the reasoning of the Caribbean Court of Justice in Noves and McEwan and overturn Matthews. Matthews decided in 2005 in respect of a penalty which was first enacted in Trinidad and Tobago in 1925 and received the approval of this court 15 years ago in Matthews under Section 4 of the Offences Against the Person Act. We respectfully submit that nothing has happened since the court took its decision in Matthews, which should cause this board to overturn the reasoning in Matthews. What I propose to do this afternoon is to provide some general interpretation principles and some context. So my friends who follow me afterwards, Mr. Stevens and Mr. Poole, can add the flesh onto the bones I propose to submit to you. The CCJ, my lords and my ladies, was established in the year 2005. Trinidad and Tobago does not have final appeals to the Caribbean Court of Justice. Our final appeals lie to the Privy Council. The CCJ's jurisdiction in respect of Trinidad and Tobago only is in respect of its original jurisdiction, that is, treaty obligations and matters in respect of differences between states that form part of the Caribbean community. That is a deliberate legislative choice made by the government of Trinidad and Tobago. The other issue which has to be considered is that each Caribbean jurisdiction is different. They have their own constitutional values and they have developed their constitutions differently. They also have different human rights provisions. They have different savings law provisions, and therefore the cases cited by my learned friends this morning have to be looked at carefully in the context of the specific constitutional arrangements made in those jurisdictions. I don't propose to go into all of the cases, but merely mention some of them to illustrate my point. The first one I wish to mention is the case of Worm, which is the electronic bundle 2505, which comes from Grenada to your Lordship's Court. There is no savings law provision in the Constitution of Grenada. There was no need to strike down Worm, and there was no need to modify, and that was expressly reserved. There is a provision in the order in council for modification, but there's nothing in the Grenadian Constitution that provides for a savings law provision. So that case has to be looked at in that light. In Bowie, in the case of Bahamas, there was also no savings law provision at the material time. In St. Jose Farmers out of Belize, that my learned friend Mr. Fitzgerald referred to me before, the savings law provision in Belize was for a period of exactly 5 years. So therefore, the court felt in St. Jose Farmers that could engage in a process of modification because the existing law clause had changed. It had been, it was no longer enforced because of reflection of time. That is 5 years. The case of Watson, which was decided together with Matthews and with Boyce, went that way because there was no equivalent to Section 6.2 in the Jamaican Constitution. So there was no issue of substituting the existing law that was in place. The case of Nimron Miguel from Trinidad and Tobago, which is in my Lordship's bundle, sought to extend and revive the felony murder rule, which is a common law rule. So there was no issue in that case at all about engaging Section 6.2 and substituting an existing law. So we say, my lord and my lady, you have to look at the constitutional context in which every case is decided.
Mr. Hussain, before looking at that, can I just get myself orientated around the submissions? And that is, I understand that you accept that the mandatory death penalty is a cruel and inhumane provision.
It is, my lord, but it does not violate Sections 405.
Yeah. But you wish to uphold it?
Yes, my lord.
Right. Okay.
Yes.
And has it been considered by the legislator since Matthew?
No, my lord.
Has there been any attempt to change the Constitution at all?
No, my lord. And I get to that in a moment.
Right. Okay.
Yeah.
And I hesitate to ask, but is there a reason why there should be a continuation of a cruel and inhumane punishment?
Lord, my answer to that is a matter of legislative choice.
Okay. But the legislator hasn't thought about it.
The legislature has not done it. I don't know, they haven't thought about it.
Has a motion, has it been discussed, or is it, I mean, I just want to get a feel of what the what the response is in Trinidad and Tobago.
Well, each country has its own mores, and no bill has been introduced in the Parliament to abolish the mandatory death penalty, although it has not been put into place for more than 15 or 16 years now, as the case may be. Now, well, I'll deal with the issue of the constitutional sovereignty and the sovereignty of Parliament within that context as I move into my submissions. But I say this, my lord, the Trinidad and Tobago has the most comprehensive shutout savings provisions in the entire Caribbean. I think, my lord, the President this morning pointed to Section 6.2, and when in fact, if a law repeals an existing law, and that law goes beyond what is permitted by 4 and 5, what is substituted in its place is the existing law, as the case may be. No other Caribbean jurisdiction has a provision like that, respectfully. Now, my little friends, Mr. Fitzgerald cited the case of Beckles and Delimore from Trinidad and Tobago. In Beckles and Delimore, again, that is not a case dealing with the issue of any modification. It is a state of emergency case, and the issue arose is whether the emergency ordinance was ultra vires sections 2 and 3 of the previous constitution, and the courts held no, and there was no issue of any modification in that particular case. Now, we say, my lord, that if we look at Section 6, and we look at Section 6 from the context of Belize or the context of Bahamas in its original constitution, if it is that the Parliament of Trinidad and Tobago wished to introduce a section that was either come to an end because of effluxion of time, or give the legislature or give the judiciary a power to modify it, they could have done so in the body of the Constitution, either in 1976, when the Republican Constitution was in force, subsequent to the 1962 Constitution, or thereafter. But in their it's a deliberate choice on their part not to include a provision like that in the Constitution. The second point that has to be made is in relation to the varying types of modification clauses contained or existing law clauses contained in the other parts of the Caribbean. Jamaica, for example, does not have a 6.2. The legislature could have gone there. The legislature could have done like Belize, for example, and put a limitation on the duration of the savings law clause. The legislature could have abolished it altogether, not have it as in the case of Grenada. So that is a deliberate choice of the legislature to do what they did. Now, we say that respectfully, and I say this with the greatest of respect to the CCJ, and I want to use 2 passages to illustrate the point that I propose to make. And the point is this, that there is no common Caribbean jurisprudence relating to how you should deal with the death penalty, because each country is a sovereign democratic country entitled to its own laws, having its own parliament and its own judiciary. And some countries may want to ameliorate the death penalty, some may want to make it mandatory, some may want to abolish it. It depends on your individual circumstances. The court is not here respectfully to give consideration to that, because that is a matter of legislative policy. Nothing more than that. We, for example, I would, for example, like on behalf of the state, to cite two passages of Sir Dennis's judgment in the Privy Council, in the Caribbean Court of Justice. The first one is at paragraph 133 of his judgment, and this is what he says.
Do you have the page number?
Yeah, it's the case of Nervis.
Yes.
Nervis.
The electronic bundle number.
Nervis is at
R6638.
yeah, Nervis is at core bundle tab 10, electronic bundle 638. That's right. Thank you very much. This is what at paragraph.
Can you just give me a moment?
Yeah.
It's always easiest to follow a lengthy quotation if we have it in front of us.
Yeah.
You know the page number?
The paragraph number is 133.
The page number of that paragraph. Do you have that?
Sorry, Miller.
You only have it in electronic form.
There isn't a paragraph 133.
I'm sorry. The proposition. I'm sorry. I understand there's no paragraph 133. But could I provide that for my lords? Yeah, Nervis here. Nervis. The proposition that judges. Yeah.
It's in Anderson.
It's 113.
113. It was Anderson.
Is it? No, sorry.
That's Anderson's judgment.
Yes.
113.
Well,
113. It's page 6.
Yeah, thank you.
is it 113? Yeah.
Well, I'm not sure. 113.
That'll be the Anderson, won't it, the dissent?
Is wanted.
No, nothing. It reads as follows, but I read it very slowly.
Yes.
The proposition that judges in an independent Barbados should be forever prevented from determining.
It's 53 at 663, my lord.
53 at 6.
Paragraph
53.
663.
Yeah. The proposition.
This is in the Chief Justice's judgment, is it?
Yes, my lord. The proposition that judges in an independent Barbados should be forever prevented from determining whether the laws inherited from the colonial government conflicted with the fundamental rights provisions of the Constitution must be inconsistent with the concept of human equality, which drove the march to independence. And then he disagreed with that, and he said, furthermore, the Savings Clause is an unacceptable diminution of the freedom of a newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. We say respectfully, my lord, that is not a sound basis upon which to establish that the sovereign democratic parliament has chosen to put into its constitution is Section 6, as it is in the Trinidad and Tobago Constitution. What we have there is what is described, for example, by Lord Hoffman, citing Sir Sidney Kentridge and Zuma, where he says that that is divination. It is not interpretation, as the case may be.
Well, just looking at what was said, so far as Trinidad is concerned, the 1976 Constitution isn't a law inherited from a colonial government.
No, my lord. The 1976 Constitution is an act of the Trinidad and Tobago Parliament.
Yeah.
It is not by way of order in council. Now,
and it's not correct. It wouldn't be correct to say for Trinidad that judges must be forever prevented, etc., because there's a possibility of amending the Constitution.
Yes, my lord, that is so. I accept that.
So it's an independent Trinidad's own provision, which an independent Trinidad can amend if it thinks fit.
If it wishes,
is that right?
Yes. Now, that brings me to another point, and it deals with the issue of where is the Constitution located? In Trinidad, the Constitution is located in a schedule to the Constitution Act. If we look at the constitutions of the Commonwealth Caribbean, they're all contained in schedules to either an order in council or, in the case of Trinidad and Tobago, an act. But they all say that the Constitution is contained in Schedule 1, 2, or 3, or the schedule as the case may be. In nearly all of them, they have a provision in the Constitution that says that the Constitution is, in fact, the Constitution is the supreme law of the particular country. If it is not stated, and that's contained in Section 1 of the Section 2 of the Trinidad and Tobago Constitution, if it is not stated in any event, it is always interpreted as the supreme law of the particular country. Now, in all the orders in council, as well as the Trinidad and Tobago Constitution Act, the Constitution isn't the entire Act. It is the schedule that is identified in the Act. For example, in the Trinidad and Tobago Constitution Act, it specifically says, it defines the Constitution as the Constitution contained in the schedule of the Act. If we look at Section 2 of the Constitution Act, at the electronic bundle 415, it says the Constitution means the Constitution set out in the schedule. Now, of course, that Constitution is described in Section 2 as the supreme law. Now, it can't be that a provision such as Section 2 that says the Constitution is a supreme law, that supreme law should be read subject to a modification provision contained in either an order in council or in the Constitution Act. In the case of Trinidad and Tobago, Section 5 of the Constitution Act, because the Constitution has to trump the order in council or the Act. And in any event, the Constitution is the supreme law. So therefore, the issue of reading Section 5 of the Constitution Act or reading any section in an order in council together with a specific provision in a constitution which is the supreme law really does not match up, because one has to be superior to the other.
But why can't you give effect to Section 5 by reading the existing laws? You're not reading the Constitution differently. The Constitution retains its status as supreme law, but the existing laws are to be read in a certain way, and that doesn't contradict the Constitution.
Well, respectfully, my Lord, if we look at Section 6, it says nothing in Sections 4 and 5 shall invalidate. So it uses the language of invalidity.
Yes.
Now, it puts it at a level where it prevents an existing law from being challenged as against 4 and 5. And that is as the law exists at the time when the Constitution came into force. Now, if it is that you read Section 5 of the Act to amend the existing law, it will no longer be an existing law. What it would be, an existing law as modified by an act of Parliament, not given the supremacy that is required by the Constitution itself. So in my respectful submission, Section 5 of the Act can't trump Section 6 of the Constitution. They are two distinct and separate entities or two different regimes operating at two different levels. The other point I wish to touch on very briefly is the issue of how do you construe Section 4.
Mr. Minister, sorry for us interrupting. Yeah. But what role is left for Section 5.1? In what circumstances, on the basis of your arguments, would existing laws be construed with modifications?
Existing laws will be construed with modifications if it does not violate 4 and 5. For example, in a case where, for example, it provides that the state should, for example, in the case of Mollison, or in the case like CPSAD, in that kind of situation, you can have minor changes, you could have minor modifications as the case may be. But what you can't do is change the essence of the law itself.
I'm not quite sure that I follow. The circumstances in which existing laws shall be construed with modifications.
So, for example, if you have the Governor General in a piece of legislation and you now have a presidency, what you can do is modify it to cater for that kind of situation.
These are existing laws. Who does the construing?
The court will do the construing, my lord, respectfully, or...
Is by the courts, is it?
Yes, my lord. Yeah. But it's not intended to construe an existing law or to modify an existing law, adapt an existing law, which violates sections 4 and 5. Because in the case of the example of the presidency, that does not violate sections 4 and 5.
Can I just... This may not be a good example, but one that occurs to me would be this, that a lot of previous laws will have referred to the Crown, yes, or perhaps to Her Majesty in Council, yes, expressions of that kind. And the 1976 Act established Trinidad as a republic, mm-hmm, with a president as head of state. Now, one consequence of that would be that there would be a lot of previous legislation which indeed would have to be modified under Section 5 of the Act in order for it to be applied in this new context. All that Section 6 of the Constitution is concerned with is inconsistencies between existing laws and the constitutional guarantees in Sections 4 and 5 of the Constitution.
Thank you very much, Lord. I think you've put it much better than I possibly could. But let's look at another thought, if I may. And it deals with Section 4 of the Offences Against the Persons Act. Now, my little friend, Mr. Fitzgerald, spoke about the separation of powers. Of course, the question of sentencing attracts the principle of the separation of powers. But what has happened is that Section 6, when applied to Section 4, results in the attenuation of the separation of powers insofar as the sentencing of a person who has been convicted of murder is concerned. See, my lord, there's a pure doctrine of the separation of powers that operates on a larger plane. But there's overlap, and it has to fit the constitutional arrangements in every single country to which is applicable. The United States of America, or Great Britain, or each Caribbean country has a different concept of the separation of powers. And this is why Lord Sumption, in the case of Ferguson, uses the word qualified. The qualified separation of powers. It's in my lordship's bundle. So what Section 6 does, it preserves the separation of power insofar as the issue of sentencing is concerned with a person who has been found guilty of murder. It reduces it, it diminishes it, it attenuates it. But it preserves the right of the legislature, because it is a safe law, to prescribe a maximum penalty. That is quite apart from the point raised by my Lord Stevens, I believe, who I think mentioned the fact that in any event under the Westminster system, and if you apply Hines, it is not unknown to have a mandatory sentence. So therefore, insofar as Section 4, my little friend spent a great deal of time on that issue, insofar as Section 4, which is the pure doctrine of separation of powers, we say because it is saved, the level of discretion exercisable by the judiciary in respect to the sentencing procedure under Section 4 is reduced. There are three other points I wish to make in this very short time. The first point is Parliament must be deemed to have knowledge of the mandatory death penalty, and yet it chose to do nothing about it. And I would like to invoke two cases to support the state's case on this issue. And the first case is DuPont. Lord Diplock's statement at DuPont, Volume 5, Tab 59, Electronic Bundle 2164. Now, that is a case dealing with the issue of tortious liability in respect of strikes. Mm-hmm. And what Lord Diplock says is that when it is, if I may summarize, when it is that the legislation was effected, probably Parliament did not see or did not comprehend the full purport and effect of that particular provision. He says, however, that legislation which gives effect to policies that are the subject of public and parliamentary controversy, in this case the death penalty, it cannot be too strongly emphasized that the British Constitution is based firmly upon the separation of powers. That is, powers that are allocated to the judiciary or the legislature, as the case may be, acting within the province of authority prescribed to them by the Constitution in the case of Trinidad and Tobago. He says it's the role of the judiciary to interpret the legislation and for Parliament to make the laws. He says further, it is not for the judges to invent respectfully fancy ambiguities as an excuse for failing to give effect to its plain meaning, because they themselves consider, or lawyers for that matter, that the consequences of doing so would be inexpedient or even unjust or moral. Mandatory death penalty is an example of that. A statute passed to remedy what is perceived by Parliament to be a defect in the existing law may in actual operation turn out to have injurious consequences, but it is not for the judiciary to decide, but is rather for the Parliament to decide. And it deals last of all with the question of the wide legislative choice in the exercise by the Parliament of making laws, which they are in the best position to do because they have an understanding of the political complexion, the government, and the state of public opinion. He goes further to say that it endangers public confidence in the political impartiality of the judiciary, and it is essential to the rule of law. He says if judges under the guise of interpretation provide their own preferred amendments or statutes with experience of the operation are shown to have consequences which members of the court before whom the matter comes are considered to be injurious to public interest, then it is for the Parliament to change. And then it goes on to say further that it is in the interest of the separation of powers, the principle of certainty, and the rule of law to allow the separation of powers, the rule of law, the sovereignty of Parliament within the context of the sovereignty of the Constitution operate in the way it was intended to operate. Now, far from advancing the principle of the rule of law and the separation of powers, learned friends invite you to use respectfully a strained interpretation based on the CCJ's judgment, which in our respectful submission is not tightly and rigidly and judicially reasoned as it should be, and interfere with a judgment of this court given 15 years ago based on a statute which is in force since 1925, in an environment in which it is bound to impact on a great deal of the existing legislation which is enforced in Trinidad and Tobago. Now, my lords asked for whether there are other instances of cases where Matthews is applied either by this court or by the local courts. And these are all in the bundles. Lendo and others versus the Attorney General, Matthews is applied. In Pittman, it's also in the bundle at tab 108, electronic bundle 3884. Lendo is at electronic bundle 3194. In CPASAD, at tab 116, electronic bundle 4304. In Nimrod Miguel, at tab 95, electronic bundle 3348. And there are others as well. In Johnson and Balwant, Lord Roger dealt with that issue as well, all very frontally. So it must be that the Parliament of Trinidad and Tobago and the government of Trinidad and Tobago, in its deliberate choice, left the mandatory penalty in place and allowed the advisory committee to do its work, as the case may be, where there's extensive natural justice rights built into the issue of whether that sentence should be commuted. It must be that, having regard, and I'm not trying to give evidence on the bar table, but to deal with my little friend Mr. Fitzgerald about they haven't sat, it may be because we are 8 miles from Venezuela. It may be because of our high crime rate. There's no evidence before the court to that effect. But the position is that Trinidad and Tobago is unique and different and geographically located differently from the other Caribbean islands. We are way down to the south, 8 miles from the South American border. The point about it is there are other cases in the pipeline dealing with this very same issue, which leave has been granted. It's the case of Suraj, which we can send copies of the judgments to Millard. It's the case of Vijay Maharaj, which is on its way to the Privy Council, leave has been granted.
Is that the sedition case?
Yes, Millard, the sedition case. That's Vijay Maharaj. Suraj deals with the public health ordinance, which was used by the government to manage the COVID-19 epidemic and to make regulations. The position is that if this court takes a certain position in respect of safe provisions, it is bound to impact on other cases, particularly in the case of Suraj, which the ordinance of which allows the executive to restrict by delegated legislation the movement of persons, masking, and matters related to the closure of business and the congregation of people. I make those points to demonstrate the impact that a modification or change in Matthews is bound to have. Now,
I'm sorry, just so I'm clear. So there's a case, is it one that's pending before the board?
Leave has been granted, and I think it's before the board now. That's Suraj.
And is this the one that's about existing laws concerned with public health regulation?
That's true, Millard.
Right. Okay.
To manage the COVID epidemic, 19 epidemic. There's another one which was argued before the Court of Appeal called Achille Charles, dealing with bail, which also deals with the same point about the issue of in which circumstances you can get bail in respect of persons who have committed murder. So it's bound to have an effect.
Yeah.
It's bound to have an effect.
It would be helpful, can I just mention, it would be helpful if you could give us a note of these cases in writing.
We'll do so, my lord.
Thank you
I
very
promise.
much.
And we provide you with electronic copies of the judgments as well if you wish. Now, my lord, I make this point because I'm going to close on this note.
Yep.
And it is this. I wish to refer the case of Matadine against Pontu, which engaged the attention of this court some time ago. Yeah. Matadine and Pontu is found at tab 91, volume 9, electronic bundle 3366. Now, Matadine and Pontu is an interesting case because Matadine and Pontu deals with an allegation of discrimination in respect of students who are required to do an examination in Oriental languages when it is that they did not have the requisite period of tuition that they thought necessary to do that particular examination. The Constitution of Mauritius was very particular about how it described discrimination. It was very restrictive. The issue in that case is whether the failure by the state to afford the appropriate length of tuition to these students amounted to discrimination. Lord Hoffman, sitting, I'm delivering a judgment on behalf of your lordships, said this. He said, first of all, the fact that there's a restrictive interpretation to discrimination in the Mauritian Constitution did not mean it is not a sovereign democratic state, a la Section 1 of the Trinidad and Tobago Constitution, which finds itself also in the Mauritian Constitution, except their Section 1 is very deeply entrenched. So democracy means different things for different people, dependent upon the political will of the Parliament and the extenuating circumstances that informs the Parliament as to how to pass a law. So that's the first point he made. The second point he made is that it is for the constitution makers of Mauritius to determine the length and the width and the breadth of their constitutional provisions. And we chose not to protect discrimination in respect of children during examinations. That is a matter for them. That is the constitutional framework within which they had to act. He says further, thirdly and most importantly, it is not for the court to extend the remit of the constitutional provisions. That is a matter for the legislature. If my lords would join me at volume 9, tab 91 at page 3377, this is what Lord Hoffman says. And I urge upon your lordships and the lady this passage, which I find is very, very, very revealing. It says, and perhaps more important, who is to decide whether the reason is valid or not? Must it always be the courts? The reasons for not treating people uniformly often involve, as they do in this case, questions of social policy on which views may differ. These are questions which the elected representatives of people have some claim to decide for themselves. The fact that equality of treatment is a general principle of rational behavior does not entail that it should be necessary to be a justiciable principle, that it should always be the judges who have the last word on whether the principle has been observed. In this, as in other areas of constitutional law, sonorous judicial statements of uncontroversial principle often reveal the real problem, which is to mark out the boundary between the powers of the judiciary and the legislature and the executive in deciding how that principle is to be applied. Now, respectfully, my lord, he goes on to say further again at page 3377, a self-confident democracy may feel that it can give the last word even in respect of the most fundamental rights to the popularly elected organs of its constitution. The United Kingdom has traditionally done so, perhaps not always to universal satisfaction, but certainly without forfeiting its title to be a democracy. A generous power of judicial review of legislative action is not, therefore, of essence of a democracy. Different societies may reach different solutions. Now, in my respectful submission, the bright line in this case is really what I call the supremacy of the legislature in the context of a constitutional supremacy. So there's a constitutional supremacy established by the Constitution. Within the framework of that Constitution, the legislature is afforded certain powers to legislate, and the judiciary is afforded powers to adjudicate. The legislature, in its wisdom, has chosen to leave in place many safe provisions. For example, in respect of income tax, customs duties, corporation tax, excise duties, land registration, regulation of properties, planning regulations. In all of these pieces of legislation, there are certain quirks that will breach the separation of powers principle in its purest context. For example, the Board of Inland Revenue can make an assessment against you, and you may appeal to the Board of Inland Revenue. They turn you down and you go to the Tax Appeal Board. So they're the first instance judges. The revenue has the power to fine you, and they impose a fine upon you, which is triple times the cost of the good. All of these are examples. Those instances certainly breach the principle of the separation of powers in its purest sense. But when taken proportionately, and when looked at as a result of Section 6, what we have is the savings provision coming into play to determine that there are existing laws, and therefore they are saved from judicial review, as the case may be. It is now left to the legislature, as it has done in several instances, to intervene. My Lord is fully aware of Nimran Migal, which is a case dealing with the felony murder rule, which is a common law rule. By passing legislation, the legislature in Trinidad and Tobago inadvertently abolished the rule. They subsequently brought into play the rule again on an extended basis. But because it was a common law rule, it was not an existing law, and the Privy Council said, no, you can't do that. They have also intervened in respect of marriages, where people could have got married in various denominational sects, whether you're Muslim or Hindu or Baptist, at age 30. They said, no, we go to 18. So the legislature reflects the sociology, the public opinion, and the logic. It is the representatives of people in whom is entrusted the powers of legislation. And the final point I want to make, Millard, before I think I have to go now, is that there's no preeminence, and that's the final point, there's no preeminence in the constitutional arrangements, beginning with Section 1. What we have are different levels of entrenchment. That's a different issue altogether. What we have is Section 1 with the Supreme Law Clause. We have Section 2, Sovereign Democratic State. We have 4 and 5, savings provisions. We have 4 and 5, human rights provisions, Section 6, savings provisions. Together, they constitute the opening chapter of the Constitution. There's a mechanism to violate 4 and 5, which is found in 13. There is also a test to be applied, even if you get the required majority in Parliament. So no provision has a preeminence over another position. What we do is we interpret faithfully, as lawyers do, what was the intention of the Parliament in the context of the section. There's no room for a generous interpretation in respect of a section which has a plain and ordinary meaning. The differences between 4 and 5 is those give you rights, so they're capable of evolving. So, for example, recently my Lords ruled on the case of supersede, where the protection of the law was afforded a very wide interpretation consonant with some of the rulings of the Caribbean Court of Justice, the Maya Alliance case and other kind. There's room in sections 4 and 5, which is an organic principle, right to life, freedom of the press, freedom of movement, liberty, as the case may be. Within that context, to develop the law on the basis of the evolving standards of decency that is the hallmark of a civilized society. Section 6 is structural, and a distinction has to be made between an organic section, which encourages the courts to amplify consonant with the evolving standards of decency that mark a civilized society, and a structural provision, such as separation of powers, supremacy of law, save law provisions, as the case may be, which in essence establishes the bones around which the Constitution is built. And the courts are more reluctant in those kind of circumstances to take examples from other countries whose structures are different and differently composed, and give them life in a more liberal fashion than they were intended to be. That is the work of the legislature, respectfully. We are engaged in an interpretation exercise, and on behalf of the government of Trinidad and Tobago, I commend to you the arguments of my two learned friends that they are going to make tomorrow, and we say in that context, there is no real reason where we can overturn Matthews, because we want certainty, we want clarity, we want good order, and we want good administration. And most of all, we want continuity. Matthews overruled Rudall. If this court were now to overturn Matthews, it will mean that we have a situation where it's almost difficult to predict the direction in which we have to go. Benny and de Freitas does not help us because of the fact that you can now interpret that someone who has been in prison for 5 years constitutes cruel and unusual treatment and punishment without striking down any law. But on the facts of that particular case, you can say in Pratt and Morgan, that's cruel. And you can overrule Benny and de Freitas as the case may be. That is not the position here. What they're asking here was something totally different. So Benny and de Freitas does not, Pratt and Morgan doesn't help us. Benny and de Freitas does not help us because the position can shift. Protection of the law also can shift and evolve as the case may be. We are dealing with a structural position. So I thank you, my lords, very much, Madame Milady, and this is my contribution on behalf of the state.
Well, thank you very much indeed, Mr. Hussain. We'll adjourn now, and we'll sit again at 10:30 tomorrow.